Hello, my name is BIG Lawal and I'm the principal partner, HARLEM. Today I want to talk about the lawful interception of communications under the Nigerian Telecommunications laws. But first of all, what is lawful interception? Lawful interception refers to a legally authorized process by which a service provider gives authorized officials access to the private communications of their subscribers, which may be individuals or organizations. The first claim fact is that none of the mobile network operators will normally record, monitor any of a subscriber's telephone communications. Yes, they have what is called call detail record, which is CDR, which provides information about the telephone calls you make, indicating specific details about the time and duration of your call, completion status, and the destination number that you made the call to. However, it is not possible for MTN, for instance, to know what any subscriber discussed with another subscriber on the phone, not to talk of recording and releasing it to another person or to any security or law enforcement agencies, unless MTN has been authorized to intercept, monitor, and record that particular telephone conversations. If they do, they will have fallen in breach of your right to privacy. The first question that bears asking is, under what circumstances can any of the mobile network operators intercept, monitor, and record my private communications with another person? Don't forget that I, like every person in Nigeria, have the constitutionally guaranteed right to privacy of telephone conversations and telegraphic communications under section 37 of the 1999 Constitution of the Federal Republic of Nigeria as amended. However, since my right to privacy is not absolute, same Constitution of the Federal Republic of Nigeria provides under section 45 subsection 1 that my right to privacy can be restricted in the interest of defense, public safety, public order, public morality, public health, or even for the purpose of protecting the rights and freedom of other persons. Therefore, any law authorizing law enforcement agency to intercept, monitor, or record my private telephone calls will be unconstitutional, null and void, if such law fails to meet any of the stipulated constitutional provisions abridging my right to privacy. Let me then go back to my evangelistic question as to the circumstances which can warrant a security or law enforcement agency to request any of the mobile network operators to intercept, monitor, and record my private conversations. I want to start with the provisions under the Nigerian Communications Act 2003. That's the principal legislation regulating the telecoms, internet services, and ICT in Nigeria, which I shall henceforward refer to as NCA 2003. Under section 147 of the Act, that's the NCA 2003. The Nigerian Communications Commission (NCC) may determine that a licensee shall implement the capability to allow authorized interception of communications. According to section 148 subsection 1c of the same act, the NCC has wide discretionary powers to direct the interception of any private communications during a public emergency or for public safety. You will observe that from the provision of section 148 subsection 1c, the NCC for the NCC to exercise this power, no court pronouncement or authorization is necessary. But this does not, in any material effect, exclude the jurisdiction of the court, since NCC's powers to direct an interception can still be subject to a judicial review once the powers have been exercised, in which case the courts would then need to ascertain whether the NCC's exercise of these powers are justifiable or justiciable and in compliance with the Constitution. Already, section 4 subsection 8 of the 1999 Constitution as amended prohibits any laws which oust the jurisdiction of the courts or judicial tribunal. In 2009, and in exercise of the powers conferred on NCC by section 70 of the NCA 2003, the lawful interception of communications regulations 2019 was established. This regulation provides legal and regulatory framework for lawful interception of communications, collection and disclosure of intercepted communications in Nigeria, while giving effect to both sections 146 and 147 of the NCA 2003. The 2019 regulation seeks to prohibit the unauthorized interception of communications and goes further to provide conditions under which lawful interception can be carried out by law agencies or state authority. According to Regulation 4, any authorized agency listed in Regulation 12 can lawfully intercept any communication where it relates to the use of communication service provided by a licensee to both a person in Nigeria and outside Nigeria. Regulation 8 provides that the interception of private communication is lawful where the parties to the communication or where the party to the communication believes that there is a threat to human life and safety, or where in the ordinary course of business it is required to monitor and record such conversation. So in closing, both the Cyber Crimes Act of 2015 as well as Terrorism Prevention Act also establish different regulatory frameworks for authorized interception of communications under the Nigerian laws. For any questions of this lecture, please feel free to send in your mail to biglaw@harlemsolicitors.com. Thank you for listening and best wishes from Harlem. Thank you.